So hello everyone, and a good afternoon for those of you who are in the same time zone as me. Thank you for joining us here this afternoon. My name is Annette Magnusson, and I am the Secretary General of the Arbitration Institute of the Stockholm Chamber of Commerce. And I will be with you for the next, well, I suppose an hour to address the topic of arbitration and climate change. And I can see that we have people joining as I am speaking. So I will wait a little bit longer before I jump into sort of the main topic. Just a few practicalities, and I might have to repeat them as we go along, as I see more people are joining. As you enter the meeting, you will be muted, so all participants have their mics turned off. We encourage questions and comments throughout the way, but I think given how many that have signed up for this hour, it would be more efficient if you all write it in the chat, and then my colleague Lisa, who is also online, she will keep track of all the questions and try to manage that as we move along. And I also expect that I will have time at the end to answer questions. So use the chat function to write your questions. I should also let you know that we have decided to record this presentation, and we will see whether the way in which you publish this afterwards has not really been decided, but I think it's appropriate that everyone is aware of the fact that we are recording this. So if that sort of in a way influences how you ask questions and so forth. So that's where we are. And I see now we have 70 plus people online, which is great. Really thrilled that so many people have expressed an interest for this topic. So starting a little bit quietly then about the presentation that you will be hearing for the next hour or so. What I will do is that I will give you an overview of the topic of arbitration and climate change, sort of the landscape, if you like, of arbitration and climate change. And my ambition is to leave you probably with more questions than answers, but hopefully this will give some inspiration to you, which will inspire you to explore some topics further in your own practice. So whether you are a practitioner, a researcher, in-house counsel, or if you are listening to this in any other capacity, that's sort of my intention, to give you a 360 analysis or picture, and hopefully after this you will have some ideas of things you want to look into further. So as you can imagine then, with all the topics that are associated with climate change, that's quite a lot for an hour, but I would rather do that to overview and rather than going into one topic in depth. So that's sort of explaining the idea here. And as I see more people joining, I just want to sort of repeat the practicalities of the meeting, that all should be on mute, although I can hear someone who is not on mute at the moment. So I asked Lisa to put everyone on mute. And then I will just speak for people who just joined.
Annette, when I put everybody on mute, I'll put you on mute too, so you need to unmute yourself when I do that. Sorry. So the last 30 seconds you need to repeat.
So I'm back. So as you can see, we are just starting up to learn how to manage this tool that we're using. So anyway, so international arbitration and climate change is a fairly new area of law, and there are many lawyers that are exploring this topic out there, and that's really a good thing. And through initiatives like this one, we hope to contribute to expanding the pool of lawyers looking at climate change issues. But perhaps before I jump into sort of the main topic of climate change, I will give you a little bit brief background of what we are at the Arbitration Institute of the Stockholm Chamber of Commerce, for those who you might not be very familiar with what we do. So that's the outline for today, just to give you an idea what we'll be addressing. I will give you, again, a small introduction of the SCC, say a few things about climate change, the starting point on climate change, the way we see it, where we are, and then dive into the question of, is there any role here for international arbitration, and what might that be? I will say a few words about the arbitration community and the contributions from the community. I think that's relevant also. And then share some practical experiences from the SCC practice. So this is what we will be looking at going forward. So looking then at the SCC and what we do at the Arbitration Institute of the Stockholm Chamber of Commerce, you will actually have today published on the SCC website the statistics from 2019. So they are, this afternoon, they will be published on the SCC website. But in essence, what we do at the SCC, we do both commercial arbitration and investment arbitration. And we have a fairly diverse caseload, both in terms of substantive issues and nationalities. If you would pick one substantive issue that we see more of than others, that would be energy cases. And some of them you might have seen in the media over the years. Traditionally, we have had a very strong East-West footprint in the SCC caseload. That was certainly true when the international caseload in Stockholm began to grow. And it's certainly true also today, although we have, again, more diverse representation in our nationalities than we did, for example, in the 1990s. So we still have a strong East-West footprint. So this is sort of the outline, and I will come back a little bit to the investment arbitration at the SCC, which could be relevant for the purpose of this presentation. Most of our cases are decided under the SCC rules, but we also have fast-track rules. We do a fair number of emergence arbitration cases, and we also look at cases under the UNCITRAL arbitration rules. So this is sort of the operational side of things at the SCC. But we also focus a great deal on policy, and this is the background to why we are addressing the topic here today. And this stems from the fact that we are associated with a Chamber of Commerce. And I think to understanding this, by focusing on efficient dispute resolution services, we want to contribute to sound and strong economic development and in the end, strong societies. And I think not least the past weeks or months in the world, we have seen that we are all very, very interconnected and we are all very dependent on healthy economies. And that's really important that we all contribute our piece of the puzzle, if you like, in that equation. So we do quite a lot of initiatives relating to policy. So that's the background to why we are talking about arbitration and climate change today. Now, if we are looking at climate change as a topic, there are obviously many ways to approach this topic. You could talk about climate science, you could talk about public policy, macroeconomics, marine biology. I mean, there are many different avenues or angles in which you can sort of analyze climate change. And for the purpose of this talk, to reflect on where we are, so to speak, we will talk from a business perspective. I think that makes the most sense in my capacity as the head of an international arbitral institution, looking at most of commercial cases. Now, even if we choose this one perspective, there are many starting points one could take. There's an abundance, I would say, of reports and facts on trying to understand where we are at this point in time relating to the climate. To briefly set the tone to where we sort of, how we approach this topic, today I have chosen to look at something called the 1.5 degree business playbook. This is the product of a business initiative on climate action, also called Exponential Roadmap. This playbook was published in January this year, and it is prepared by business and academia to really target the needed economic transition to meet the climate change targets. So it was produced by companies such as Ericsson here in Stockholm, the World Wildlife Foundation, the Stockholm Resilience Center, the Potsdam Institute for Climate Impact Research, and many others. And I think it gives a really useful, quick overview of the transitions that need to happen, not least in the private sector going forward. So answering the question and looking at the playbook, what is sort of the analysis of where we are? And this I will sort of quote from the starting point from for today. And I quote here from the playbook, which just says the following: to achieve the 1 degree Celsius ambition, global greenhouse gas emissions must stop growing by 2020, and we must have emissions every decade to approach net zero by 2050, while at the same time removing some of the carbon already emitted in the atmosphere. Doing this will require the fastest economic and societal transition in history, but one which is both necessary and achievable, and will bring significant benefits from reduced pollutions to improved health and potential economic growth. So this is sort of the starting point from a business perspective, and I think here also arbitration can play a role, and I will come back to that. You may have heard of the Swedish researcher Johan Rockström, and he has sort of formulated the so-called the carbon law, which I think is useful, and this sort of summarizes what I just said, that the world needs to stop emissions growing by 2020 and have them every decade until 2050 to keep global warming to maximum of 1.5 degrees Celsius. This is really a very strong target and an important one. What I do find attractive and useful about guidelines such as the exponential roadmap is that it really focuses on simplicity, but also on speed, because this needs to happen now. I also think it's important that climate change efforts are tied with bottom line objectives of corporations. Because personally, I believe that this is a really valuable path going forward if we want to have visible results. There is just simply a lot of power to be found in connecting the private sector with climate change mitigation efforts. The positive impacts on societies, and including the environment at large, should really be an important part of corporate KPIs and measures of success. And for many companies, this holds true today. They have become quite advanced on that, but I think that probably needs to increase going forward. And the question we as lawyers could ask ourselves in this scenario is, now how can we use the law to accelerate climate change efforts? There has been a surge on the focus on the law in climate change efforts recently. So, for example, you might have seen a number of climate change litigations going forward. There are a number of NGOs focusing on the use of law for climate change purposes, and including, for example, how to use corporate law to fight against climate change. And that could be, for example, to block developments of certain kind and using sort of the existing law for climate change purposes. When it comes to using the law for proactive measures, we have not seen so much of this yet, in my mind. But hopefully we will see more of that going forward. I think there is an increasing awareness that the law is important, and that it is an important piece of the puzzle for climate change initiatives. At least in the conversations that I have been having, that's truly my impression. And this sort of becomes a segue then into the topic for this talk, arbitration and climate change. Is there a role for arbitration in climate change efforts? And I'm telling Lisa, honey, I'm trying to shift. There you go. That was too fast. There you go. There you go. So to answer the question, if there isn't a role for international arbitration in climate change initiatives or efforts, I think it could be useful to first take a step back and sort of look at the bigger picture. A really strong or major problem for international environmental law at large, and that would be including climate change law, is that it really lacks strong teeth. There are really no strong enforcement mechanisms in any of the instruments that are part of this body of law. And this gap is regularly pointed out as a weakness in the current legal regime of climate change. But the background is simply this, that it has not been politically possible to include any strong language on enforcement in this instruments. So it's sort of, if you have a strong language on enforcement, you will not have equally strong language on commitments and vice versa. That's sort of the equation that has been very difficult to solve. if you look, for example, at the United Nations Framework Convention on Climate Change, the UNFCCC from 1992, but also on the additional texts that have been negotiated as a result of the yearly conference of the parties under the UNFCCC, the COPs, and here household names, of course, are the Kyoto Protocol, and then most recently the Paris Agreement. Many or most of these instruments are governed by countries reporting their performance, reporting their performance under the convention. So rather than a strong mechanism for enforcement. Now, looking at the UNFCCC, there is an article in the UNFCCC that gives an opportunity to the parties to declare that they accept arbitration according to procedures which shall be decided by the Conference of the Parties. But we do not yet have a Conference of the Parties that has addressed these rules of procedure under Article 14 of the UNFCCC, so that's still an open question. If you're looking at the Paris Agreement, each signatory shall report its intended climate actions for the purpose of reducing the greenhouse gas emissions. So these reports are also referred to as the Nationally Determined Contributions, or the NDCs. And the parties have a binding obligation to communicate their NDCs every 5 years. But it's interesting to note here that the obligation is to report, but it's not an obligation on the content of these NDCs. So it's a commitment on procedure and not on result. And another sort of interesting detail here, I think could be worth looking into more, is that the content of the NDCs is that is sort of reported by the signatories to the Paris Agreement. It's not really formally part of the agreement. So that in itself could raise a host of issues on the strength and the effectiveness of the NDCs and these commitments. Now, also the Paris Agreement has a mechanism to oversee implementation and compliance of the agreement. But again, we do not have any details because they have not yet been decided. Now, this lack of enforcement mechanism has also been addressed in the International Bar Association published a report on climate change, justice and human rights in 2014, which has a very, very good overview and a host of issues related to climate change and the law. And this report also targets or points out the fact that there is no enforcement. So, for example, stating that there is no international body with specific jurisdiction for international environmental law claims, and continuing on saying, quote, and here I quote, no dispute resolution body exists at the international level with specialized subject matter expertise to hear and determine environmental and climate change matters. Now, over the years, there have been different proposals for courts for the environment, and they have been advocated in different models for this. But so far, we have not seen any agreement on a multilateral level on this topic. And I think the question that then could be asked, if we're talking about sort of coming from an arbitration perspective, should we really aim for a multilateral instrument at this point? I mean, do we really have the time to wait for this? Or maybe we could be better off by using what we already have in terms of enforcement to propel climate change efforts. And I think you have already guessed my answer to that question. I think we can work with what we have. So if we go down that avenue, what can we do using international arbitration to enforce climate change ambitions? Looking at international arbitration, we know that climate change mitigation and adaptation efforts require massive investments at global scale. And there, again, there's an abundance of reports and numbers out there really illustrating the magnitude of the transition that needs to happen in all societies, really regardless of where you are in the world. And I will not throw these numbers at you here, but I'm happy to sort of point you in certain directions if you want to contact me after this presentation. But so one answer then to the question of what can international arbitration do in this context when it comes to climate change efforts, one answer could be that, well, arbitration should continue to do what it has always done. It should enforce contracts and be sort of that enforcement bar of international trade and economic development that it has been so successfully for such a long time. But obviously, the purpose of this talk is not only to say, well, let things stay as they are and keep doing what you're doing today. So the idea is trying to find ways to enhance the role of international arbitration in climate change efforts. And I think it could be interesting to take a look at the arbitral procedure in itself. And I think there are two details that could be addressed in this context. The first one is the principle of confidentiality, which we find very dominant in international commercial arbitration. And most international arbitrations are confidential. So, for example, if you look at the SCC rules, Article 3, it states the following: unless otherwise agreed by the parties, the SCC, the arbitral tribunal, and any administrative secretary of the arbitral tribunal shall maintain the confidentiality of the arbitration and the award. But if we move then into climate change context, we know that the sharing of information can be quite powerful and also very relevant. And I think if we revisit the principle of confidentiality, much can be gained by sharing what I call climate-related dispute intelligence. So facts from pending or previous disputes simply could be a valuable litmus test, what could work going forward. It could also be something that could spur change. It could increase future action, and really to have more transparent insight into what is actually happening on the ground, how business is contributing to climate change efforts could be a good thing going forward. So we could ask ourselves if the inherent characteristic of confidentiality of international commercial arbitration, in fact, is a hurdle for arbitration's capacity to play a role for climate change efforts. Again, if we look at outlook at international environmental law in general, we see that transparency and reporting is a really strong tool for implementation of international commitments. It works to various degrees, but in general, transparency can be quite a powerful thing. And we can also see how publicity surrounding climate change litigation around the world has contributed to climate change awareness. I think the first case that really traveled from the court to the general media, including daily newspapers, was the Agenda case in the Netherlands, where the final decision from the Supreme Court in the Netherlands came down just in December last year. But there are many more examples of that. And again, it sort of spurs climate change awareness. Now, I don't have a ready answer to this question. I don't have a concrete proposal. I think there's something we need to talk more about going forward. But the question needs to be asked if international arbitration should consider deviating from the normal confidentiality in cases with a bearing on climate change. Again, I think there could be inspiring details to be shared on how the private sector really is building a low-carbon society. The next question on procedure, which could be worth addressing, is applicable law. Should an application of a provision on applicable law be expanded in certain cases to address all issues of relevance for a particular dispute? And that could then include laws or rules of law regulating matters relating to climate change. Or you could put this in other words and ask the question where a dispute has consequences beyond the immediate parties, should the tribunal then consider a wider interest when deciding the dispute? This is a discussion that has already been going on for some years, and you might recognize some of you from the investment arbitration context, where this has been discussed in relation to human rights. And then the question has been that if tribunals should look beyond the immediate parties when calibrating the standards under bilateral investment treaties. And if so, if that becomes the standard, could then climate change law issues be introduced into a dispute? This is an open question, but I do think it's worth discussing going forward. If we look at the corporate sector, there is a positive trend that not only the corporate sector, but also sort of the general regulatory environment and corporate codes, to an increasing extent, reflect an intention by corporations and governments really to support the implementation of the Paris Agreement. So hopefully, to an increasing extent, this will also be visible in arbitration cases going forward, as cases are being decided under the applicable rules and laws. Exploring then how climate change policy and commitments and law can be integrated into the dispute resolution procedure is also something that is discussed in this report from the Task Force on Arbitration and Climate Change Related Disputes. This is a task force from the International Chamber of Commerce that was, and the report was published at the end of last year. And the SCC participated in the work of the task force. I think this is also a very nice illustration of how climate change really cuts across institutional boundaries, that we are cooperating to really jointly find the best solutions possible. The idea here was to look at climate change related disputes and resolving these disputes through arbitration and ADR. And many of the ideas you find in this report allude to the issues that I have just addressed: transparency, confidentiality, and also applicable law. And there are also other procedural issues that are being addressed. Climate change related expertise, the need for this. And here, of course, that will be relevant for the appointment of arbitrators and experts. There might be need for urgent and early resolution of disputes. You could use the emergency arbitrator procedure and interim measures in general. And there could be examples of the need for third-party participation. All of these procedural issues are, of course, available already today in other arbitration cases. They are not unique for climate change-related disputes. But there could be special consideration to take into account when they are applied in climate change-related cases. I should say also, when we talk about sort of climate change-related disputes, as for the purpose of this report, what does that mean? Well, in essence, it includes specific contracts for transition, adaptation, or mitigation contracts sort of specifically in line with the Paris Agreement. But also other general commercial contracts that are impacted by transition, mitigation, and adaptation measures under the Paris Agreement. So it's a very wide understanding of what climate change-related disputes are. So, so much then for the arbitration procedure. And again, I'm happy to take your questions going forward, and perhaps we can save them for later. But another area to look at, if we're talking about arbitration and climate change, of course, is ourselves, the arbitration community. What's going on there? I think this is relevant because every business needs to be part of driving the societal change that we need to see going forward. And what can we as members of the arbitration community do? I think the past month, for one, has demonstrated that there is a lot we can do and are in effect currently doing to reduce our carbon footprint. Many of you might be familiar with something called the Green Arbitration Protocol, which is a protocol or a pledge introduced by the international arbitrator Lucy Greenwood. And I was looking at this as I was preparing to speak here this afternoon. And now, the way we are today in the world, with the way we are now doing our jobs from our homes and from remote locations. Now, as it turns out, if you do not sign up to the Green Arbitration Protocol in practice that Lucy Greenwood has produced, if you do not sign up to this protocol today, I think if you're not able to do that, you cannot probably do your job today because of practicalities of today's world, given where we are from the corona crisis. So I'll just give you some examples from this protocol. So if, as a signatory to the Green Arbitration Protocol, you make the following commitment, and here I quote: "As a dispute resolution practitioner committing to ensuring that I minimize my impact on the environment for each and every negotiation or dispute I am involved in, I promise to consider and question the need to fly at all times, correspond only through electronic means unless hard copy correspondence is expressly required in the circumstances, request that electronic rather than hard copies of documents to be provided to me, Discourage the use of hard copy bundles in hearing rooms. As an arbitrator or mediator, I will suggest, and as counsel, I will consider, where appropriate, that witness give evidence through video conference rather than attending hearings in person. And the text goes on. So, like I said, if you do not follow this protocol today, I think you would probably have difficulties doing your job in the wake of the corona crisis. So this is interesting. And I do hope that there will be lots of signatories to the Green Arbitration Pledge going forward. Now, if we're looking at sort of a more general level for the arbitration community and the arbitration community as a business, if you like, I think it could be worthwhile to go back to the 1.5 degree Celsius business playbook and sort of how to build a strategy for exponential climate action from a business perspective, and use this checklist, if you like, and apply this in an international arbitration community context. So the first one then would be to reduce your own emissions. That will be the starting point. So that will be mapping out your own greenhouse gas emissions, decide on how you plan to eliminate, and develop a plan for this. If you look at the arbitration, if you can look at, for example, the data that is available from surveys from law firms, it turns out for the law firms, it is the powering of offices and air travel. They are the most likely to be the main contributors to a firm's carbon footprint, which is, I think, relevant from an arbitration context as well. So this is probably what we should be looking at. Number two then on this sort of checklist would be to reduce your value chain emissions where you can. Look for digital options. And again, the past month or 2 months for some has really demonstrated that the tools are there, the ability is there. And if you're looking at sort of the value chain or even the supply chain of your practice, you can see that there is probably a large portion of your carbon footprint. Again, going back to some of the surveys that have been done from law firms, 80% of the carbon footprint appears to stem from the supply chain of many of the law firms. So having a focus on that could really make a big difference. Now, third then is to really integrate climate in your business strategy. So, for example, enable your clients or encourage your clients or your customers or your partners, whoever your relationships, what they look like, to take decisions that are positive for the climate. And again, that when organizing a hearing, we are learning today that we can use a lot of virtual options and that they are useful and they work and they can be trusted. And with this knowledge, I think it will be a big difference going forward, how we integrate climate change efforts in our business strategies with the experiences that we are now building. And 4, on this checklist, really take part in the work that the society is doing in terms of climate action. I think as lawyers, as advisors, as academics, you are all very well placed to do exactly this, sort of to go beyond the most immediate business interest, if you like. A very concrete action proposed under this 4th item on the checklist is the following, which I think resounds very well, for example, with something that we're doing, but I'm sure others could subscribe to this as well, that, here I quote, we should join and contribute in business trade organizations which are committed to a 1.5 degree ambition and avoid those that are counteracting those ambitions. Participate in national and international events which demonstrate concrete solutions to help scale best practice solutions. Again, this all sounds very simple. It goes back to what I said at the beginning, that the efforts could focus on simplicity and speed. But sometimes the simple actions are the most that we overlook, most common. The sort of, this is very easy to do. This is something we can start doing tomorrow or this afternoon even. I think a 5th item on this checklist also could be that we sort of report on our progress to each other. Basic principles. communicate your ambitions, back them up with your strategies, and share your results, both internally and externally. And again, inspire others to do the same. And with this, it will be a collective action. This transition that we are looking for in society cannot rest on one group of actors doing everything. It will require everyone doing something. And by inspiring each other, by sharing our smart solutions, our best practice, also in an international arbitration context, I think we can all contribute in our different capacities. With this, I would like to move forward to the topic of the practical experiences of international arbitration and climate change, and speaking then from an SCC perspective. What does sort of the footprint of climate change efforts or issues look like in the caseload of international arbitration today? There is more on this topic in the ICC report, and the SCC reported to the ICC task force for the purpose of sort of sharing this data. So there's more in that report. So I'm just sharing some of the experiences and some of the numbers from the SCC practice. The infographics you see ahead of you now is summarizing a report that we published last year at the SCC, conducted by a researcher looking through the SCC cases relating to green technology disputes. And this is, you can see this sort of as our contribution to climate-related dispute intelligence that I was talking about earlier, to see what's happening on the ground. We did this to understand, one, what is the size of these types of disputes at the SCC currently, but also to see what is the nature of green technology disputes at the SCC, and are there any issues that might be common between these disputes. Now, this is the first of these studies we have done, so I'm expecting that in another 3 years, we will look at more disputes. I should say that the disputes in this report are for cases between 2012 and 2018. And it will be interesting then going forward, if we do this exercise in 3 years' time again, if we can see what has been in the change and really get also a litmus test there, what's happening on the ground. And green technology, I should say here, is sort of defined as any process, product, or service that reduces negative environmental impacts in support of the Paris Agreement. So we sort of made this definition ourselves as we were doing this research, just to come up with what kind of cases we will be looking at. In the report, there is 30-some cases being reported. Most of them are sort of traditionally delivery agreements, but also a fair number of construction agreements in this category of cases. There are some of them that, from sort of a dispute intelligence perspective, might have been interesting had they been sort of a transparent in a transparent setting in terms of sharing experiences and maybe contributing to something going forward in future business endeavors. So that would be include, for example, there was one case related to software for wind turbines. There was one case that related to production of electricity and whether it met agreed standards, and that related in turn to the connection to the general grid and how that was sort of governed in the project. So these are issues I think that could be lifted to a general level at some point and might have been interesting. But so far, all the cases at the SCC are confidential, so it's general information in the report you will find. What I do think also is interesting is that about 20% of the cases that we found were decided under the expedited rules. So it's really illustration of these are both large and small projects, and they're sort of all over the scale in terms of actors becoming involved in what we now have decided to call green technology disputes. The report also targets climate change and investment arbitration. I don't know how many of you are very familiar with investment arbitration. So just briefly, for those of you who are not, and those of you who are, you can just bear with me. But we have, since the end of the 1950s, seen the conclusion of 3,000 some bilateral investment treaties across the world. And typically how they work is that governments give a catalog of obligations that they undertake, where they give guarantees to investors from the other state with which they have signed this bilateral investment protection agreement. So this catalog of investment protection usually includes issues relating to, for example, unlawful expropriation, discrimination, an obligation to provide relevant protection and security, and in general, fair and equitable treatment. Very sort of generally described. And the majority of these treaties also provide for arbitration between investors and the state if an investor from one of the countries is of the opinion that the government did not live up to the obligations as described in this sort of catalog of investment protections offered by the state. And in many of these treaties, the fora that the investor can opt for is the Arbitration Institute of the Stockholm Chamber of Commerce. So we know of about 120 bilateral investment treaties, including the SCC in this Investor State Dispute Resolution Clause. And we also have the SCC included in the Energy Charter Treaty, which is a multilateral investment treaty. And against this background, we have seen a lot of investment disputes here in Stockholm. We have had more than 100 of these cases since the first case in 1993. So this has led us to also look at investment arbitration for the purpose of climate change issues. Now, one question that has been asked by many authors, I would say, and academics, is that in the context of climate change and investment arbitration, could the standard of protection as offered in these bilateral investment treaties, together then with the force added by enforcement through international arbitration, which again you have in so many of these 3,000 agreements, could this combination be a force of good to address climate change? I mean, this would be an example of sort of working with what we have, as I alluded to earlier. We haven't seen a lot of cases yet where you could say that this is really happening, but there are some interesting examples of cases that sort of makes you think that it will be interesting to see what will happen going forward. I will mention one case from 2016, which was a case between a Canadian investor and the state of Barbados under a bilateral investment treaty between Canada and Barbados. And really, a long story short, here in this case, the Canadian investor argued, among other things, that Barbados had failed to fulfill international environmental obligations under international environmental treaties, and that this constituted a breach of the standard of full protection and security under the bilateral investment treaty. Now, this claim was ultimately dismissed by the tribunal, and as with many investment awards, it is published, so it's public. But in the award, although dismissing the claim, the tribunal notes that, and here I quote, the fact that Barbados is party to the Convention on Biological Diversity and the Ramsar Convention does not change the standard under the BIT, although consideration of a host state's international obligations may well be relevant in the application of the standard to particular circumstances. So, although in this case, not leading to a conclusion by the tribunal that there had been a violation of the BIT at hand, it appears, in my mind, that the tribunal opens the door to bringing in obligations as defined, as in this case, by international environmental law when calibrating a standard under the bilateral investment treaty. So this is interesting. Some trade agreements or bilateral investment treaties also include direct references to international environmental law or climate change law. So, for example, just mentioning two examples, there is the Peru-United States Trade Promotion Agreement from 2006. And here the agreement states that the parties, and here I quote, shall adopt, maintain, and implement laws, regulations, and all other measures to fulfill their obligations under, and then it goes on under a specified list of multilateral environmental agreements. in the Netherlands model investment agreement from last year, it is stated in the agreement the following: within the scope and application of this agreement, the contracting parties reaffirm their obligations under the multilateral agreements in the field of environmental protection, labor standards, and the protection of human rights to which they are party, such as the Paris Agreement. And then the text continues. So I think it's interesting that there is a cross-reference in between international agreements like here and international treaties. And I think this might be a crossroad where international arbitration could, in practice, be used to put force behind the words of international environmental obligations, and that would then include climate change law. But we haven't seen that yet in practice, so we will see if this is an area that will develop going further. I will conclude by rounding off this and saying a few words about the future, or what can we expect going forward. One development that has been discussed in recent years is what is being referred to as domestication of international law. So having international law really have an effect at national level in national courts. And of course, the possibility of having that happen will depend on each different jurisdiction and what effect international treaties are given in the national legal system. But there are some interesting examples if you look at climate change law. Again, the Urgenda case in the Netherlands, I think, is an interesting example of this, where the Netherlands' commitment and or capacity as a signatory to the UNFCCC had an effect in the decision by the national courts and their view on the Dutch government's ambitions to curb greenhouse gas emissions. There are other examples of this. There is a case recently from England relating to a runway at Heathrow, and the fact that the Paris Agreement, it was not, or to expand the runway at the Heathrow was not compatible with commitments under the Paris Agreement. There is a pending case in Norway relating to additional concessions being granted by the Norwegian government, and in parallel to being a signatory of the Paris Agreement, and this is currently being looked upon by the Norwegian courts. And I'm sure there are many, many others that I am not aware of. But I think this is an interesting development going forward. Will we see more examples, and not only in court cases, but also in sort of how policy is being advocated and formulated from a proactive purpose as well? Will we see more examples of where the actual fact that governments have committed to, for example, the Paris Agreement, will have effect on the ground because they are being asked to give it more effect on the ground by different parties acting in their different jurisdictions? I think that's an interesting development to follow. And I think also the experiences that we had from the Stockholm Treaty Labs that some of you might be familiar with could give some inspiration for the future. So the Stockholm Treaty Lab was a crowdsourcing competition that we launched in 2017, and the winners were announced a year after. And really what this was all about was to re-engineer law, in the sense that we were looking at the needed investments in society to meet the Paris Agreement targets, and the legal framework that will need to be put in place at international level to support, encourage, and attract those investments. That's really the base of the Stockholm Treaty Lab contest, and it was a really, really inspiring exercise, and I encourage anyone that is interested in this topic to really visit the Stockholm Treaty Lab website, where you can find out more about the background to the competition, but more importantly, the result, not only the commended teams, but also other teams' submissions, because all of the submissions really include interesting details when it comes to climate change in investments going forward. And one question that I think is interesting, and I hope the answer to that question is yes, is that will we use crowdsourcing for more legal re-engineering going forward? I think climate change is an area where there are traditionally knots that we need to try to address in terms of, it's a long-term problem, but we need to also be able to tackle short-term situations. And are there ways in which we can move these the knots outside of the negotiation, or so to speak, policy problems, moving outside of the negotiation rooms to the crowd, and this is on a global level, and then take the results back. I do hope that we will see crowdsourcing be used more for the purpose of addressing climate change policy going forward. With this, I have come to the end of me talking, so I think we have 10 minutes where I can open up for questions, and I turn now to Lise, if you want to help me in moderating this, since you have been the one keeping track of the chat, or potentially also been receiving emails.
We do have a couple of questions for you. So my first question here is from Rafael Miniciosi. I'm sorry about the pronunciation of the name. I'm sure I butchered it. So the question goes, since you're talking about BITS and ISDS, could a multilateral investment agreement be the most effective tool in order to eventually impose common sustainable development and climate change obligations on foreign investors?
Thank you, Rafael. I think you could probably, if you could have all the buy-in in a multilateral agreement, that would probably be very efficient. Now, the problem, of course, being to get that buy-in from as many states that you would need, or from as many emitters, greenhouse gas emitters that are at the high end that you would need. That has always been the challenge throughout the negotiation of all the instruments in climate change law, and I think even if you do a multilateral investment agreement, that will be still an issue. So, I mean, that was one of the issues that we wanted to address with the Stockholm Treaty Lab, and again, there are some interesting ideas there. And if you look at the two commended teams, they both have very, very valuable ideas there, but they come about it in different ways. So yes, I would like to say yes, that will be the most efficient, but from a pragmatic political standpoint, we might not have time to wait for a multilateral agreement like that to really be negotiated. So we might have to take bits and pieces and insert into what we have today. That might be, in practice, the more efficient way to go about it.
Perfect. We have a couple more questions. So my next question is, do you think climate change disputes could be covered by the recently launched Hague rules on business and human rights arbitration? Isn't climate change impeding on human rights after all? Right to stable, clean, viable environment and so forth. For instance, toxic spills by big oil corporations could hinder both the environment and human rights of local communities. Would it be viable to resolve such disputes under different rules for climate change and human rights?
Thank you. No, there's a strong connection between climate change issues and human rights, and I would like really to sort of recommend looking into the report from International Bar Association, where this is really at the forefront. So there are many interconnections there for sure. I looked at the draft of these rules for human rights at the very beginning. I haven't reviewed in detail the most recent version, but I suppose it would go down to sort of when you're looking at the applicable law, right? So that the tribunal is set to where they are set to assess a situation or a case. What are the boundaries that they are given when it comes to the applicable law? But in general terms, I do think the more we can see that a number of important areas are interconnected, and the less we reside in legal silos, the better.
Perfect. We have one last question, unless anybody wants to add more questions, and it's from Andres. Would it be feasible for a state to initiate a counterclaim based on the Paris Agreement or the Kyoto Protocol against an investor who has contaminated with their investment?
I think in general, the more equal playing or level playing field that you have between states and investors is a good thing. So I suppose it would be you would have to look at the treaty that you have been filing this case on to see what are the capacities or what are the options available for states when it comes to filing counterclaims. I know that there are some treaties that are opening up for that, and not and there have been some other cases where this has happened. So I suppose that will have to be decided on a case-by-case basis.
We have one more question coming in from Nicola. What are the provisions of the UNFCCC/Paris Agreement that would be relevant to an investment dispute?
Good question. There you have a topic for future research. That I must admit that's not an issue that I have specifically looked into, but it sounds like a very interesting sort of intersection between the two fields. So I think that would be a very good topic for a thesis for someone going forward. Sorry not to be able to give you a better answer than that.
I think that was the end of our question. We have also one question, that is whether or not the slides will be available. And yes, we will email the slide to everybody who signed up for the seminar after this presentation is concluded. And we will also, as Annette mentioned in the beginning here, we have recorded this. It's our first time trying to record this, so we will need to evaluate how that panned out before we see how and where we share that. And let me see if we have no more questions right now. So I leave the final word to you, Annette.
Well, so there's nothing left for me to do but to thank everyone for joining, and thank you for your attention. And just to let you know that if you want to continue this conversation offline or via email, we are happy to continue the conversation and keep moving this topic forward, hopefully. So thank you all, and stay safe.